The moment I saw the certified letter from the Pine Ridge Estates Homeowners Association, I knew my peaceful morning was about to go sideways. But nothing could have prepared me for the absolute absurdity that was about to unfold over my 100-year-old barn. I stood on the porch of my farmhouse in rural Wisconsin, just outside Stevens Point, watching the morning fog lift off the fields. My property had been in my family since 1923, a solid 102 years of Ingram history on this land. The barn where I stored my snowplows, salt spreaders, and winter maintenance equipment had been standing since my great-grandfather built it with his own hands. Now, apparently, some HOA board member with too much time on her hands thought she had authority over it. I ripped open the envelope and pulled out the official-looking document. Notice of violation and fine assessment, it read in bold letters across the top. My eyes scanned down to the meat of it. I was being fined $500 for unauthorized storage of commercial equipment in a residential zone and failure to maintain aesthetic standards as outlined in Pine Ridge Estates covenants, conditions, and restrictions. The thing was, I had never signed any CCRs. I had never joined their HOA. I had never even considered myself part of Pine Ridge Estates. The subdivision had sprung up around my property over the past 5 years, eating up what used to be the old Hanson farm to my south and the Morrison property to the east. Developers had come in, carved up the land into neat little quarter-acre lots, and slapped up cookie-cutter houses faster than dandelions in spring. My phone rang before I could finish reading the notice. It was my neighbor Tom, whose property sat on the other side of the road, also predating the subdivision by decades. "Let me guess," Tom said without preamble. "You got a letter from the HOA. How did you know?" "Because I just got one too. They are claiming my chicken coop violates some ordinance about livestock. My family has been raising chickens on this land since before their parents were born." Tom's voice carried the edge of a man pushed too far. "There is a woman coming around tomorrow for some kind of inspection. Patricia something or other." Of course, it was a Patricia. I could picture her already. Mid-40s, asymmetrical haircut, probably drove a white SUV with those stick-figure family decals, and definitely asked to speak to the manager at every possible opportunity. "This is insane," I said, looking back at the letter. "They cannot just decide my property is part of their subdivision." "You would think," Tom replied. "But apparently they filed some kind of blanket declaration with the county that includes all properties within certain boundaries. I am calling my lawyer tomorrow. You should too." After we hung up, I spent the next hour digging through my property documents. My deed was clear. My land, all 43 acres of it, had been continuously owned by the Ingram family since 1923. There were no HOA covenants attached to it, no restrictions except the standard county zoning regulations, and certainly no obligation to pay fees or fines to Pine Ridge Estates. The barn they were complaining about sat about 200 yards from my house, a classic red structure with white trim that I maintained meticulously. Inside, I kept the equipment for my snow removal business. Nothing about it was commercial in the gaudy sense. No signs, no advertising, just a working barn on a working property. I ran a legitimate business that served the community, clearing driveways and parking lots all winter long. It was honest work, and that barn was grandfathered into every conceivable regulation. The next morning, I was up early servicing one of my plows when I heard a car pull up my long driveway. I checked my watch. 7:45 in the morning. Through the barn door, I could see a white Lexus SUV parking near my house. Right on cue. I wiped my hands on a rag and walked out to meet whoever had decided to trespass on my property this early. A woman stepped out of the SUV, clutching a tablet and a manila folder. She was exactly what I had pictured. Blonde highlighted hair in that "let me speak to your manager" style, oversized sunglasses despite the overcast sky, and an expression that suggested she smelled something unpleasant. "Lawrence Ingram," she called out, not bothering with pleasantries. "That would be me," I said, keeping my distance. "And you are?" "Patricia Meredith, president of the Pine Ridge Estates HOA board. I am here to conduct an inspection of your property regarding multiple violations." "You are here to trespass, you mean?" I crossed my arms. "I do not recall inviting you onto my property, and I certainly do not recall being part of your HOA. Patricia's mouth tightened into a thin line. "Your property falls within the boundaries of Pine Ridge Estates as registered with Portage County. That makes you subject to our covenants and regulations. Now, if you would cooperate, this will go much smoother." "Show me the document that proves my property is part of your HOA," I said. "Because I have my deed right here, and it says nothing about any homeowners association." She tapped on her tablet with one manicured nail. "The master declaration was filed with the county in 2020. All properties within the designated boundaries are automatically included. You should have received notification." "I did not receive anything because you cannot just declare someone's property part of your HOA without their consent. That is not how property law works." Patricia's eyes narrowed. "I do not appreciate your tone, Mr. Ingram. The HOA board has the authority to enforce standards across the entire community. Your barn is an eyesore that violates multiple aesthetic codes, and that equipment you are storing constitutes a commercial operation in a residential zone. The fines are valid, and they will continue to accumulate at $50 per day until you comply." $50 per day. I did a quick calculation. That was $18,250 per year for storing equipment in my own barn on my own property. "Get off my land," I said quietly. "If you want to have this conversation, do it through lawyers." "Excuse me," I said. "Get off my property. You are trespassing. You have no authority here, no invitation, and no right to conduct any kind of inspection. Leave now, or I will call the sheriff." Patricia's face flushed red. "You cannot speak to me like that. I am the HOA president, and I am the property owner who just told you to leave. Go." She stood there for a moment, clearly unused to being dismissed. Then she spun on her heel, marched back to her Lexus, and peeled out of my driveway hard enough to spray gravel. I watched her go, then pulled out my phone and called the lawyer my family had used for years. Robert Langston had handled everything from my grandfather's estate to my business incorporation. He was in his 60s, sharp as a tack, and did not suffer fools. When I explained the situation, he was silent for a long moment. "They cannot do that," he finally said. "You cannot unilaterally include someone's property in an HOA without their explicit consent or without it being part of the original purchase agreement. Did you buy your property from the developer?" "No, it has been in my family for over a century." "Then they have no case." "But I need to see this master declaration they filed. Can you go to the county recorder's office and get a copy?" I drove to the Portage County Courthouse that afternoon. The recorder's office was in the basement, a maze of filing cabinets and microfiche machines despite their recent digitization efforts. A helpful clerk named Susan looked up the declaration Patricia had mentioned. "Here it is," Susan said, pulling up a document on her computer. "Filed in October 2020. Pine Ridge Estates Master Declaration of Covenants, Conditions, and Restrictions." She printed it out for me, all 47 pages of it. I skimmed through the dense legal language until I found the boundary description. According to the document, Pine Ridge Estates included all properties bounded by County Road MM to the north, the old railroad easement to the south, Highway 51 to the west, and Riverside Drive to the east. My property fell squarely within those boundaries. But there was a problem with their filing, and it was a big one. "Susan," I said, "can you look up the individual property deeds within these boundaries? Specifically, properties that predate 2020, she tapped away at her keyboard. "Sure, what am I looking for?" "I want to know if any of these pre-existing properties actually signed on to be part of this HOA. It took about 20 minutes, but Susan compiled a list. Within the boundaries Pine Ridge Estates had claimed, there were 6 properties that predated the subdivision. Mine, Tom's, and 4 others. None of them had any amendments to their deeds indicating HOA membership. None of them had signed the CCRs. The developer had simply drawn boundaries that included existing properties and filed the declaration as if that made it legitimate. "This is fascinating," Susan said, adjusting her glasses. "I do not think they can do this. You might want to talk to the county attorney." I took all the documents to Robert's office. He spread them out on his conference table, reading through everything with increasing interest. "This is either incompetence or fraud," Robert said finally. "My guess is the developer wanted to make their subdivision look bigger than it was, so they drew generous boundaries. But you cannot simply declare someone's property part of an HOA. Each property owner has to voluntarily agree to the restrictions, usually as a condition of sale. Since you never purchased from the developer and never signed anything, these covenants do not apply to you. So what do I do about the fines? Ignore them. They are meaningless. But I am going to send a cease and desist letter to this Patricia Meredith and the HOA board. And I think we should file a quiet title action to explicitly confirm that your property is not subject to their restrictions. How long will that take? Couple of months, probably. In the meantime, do not pay them a penny, do not acknowledge their authority, and if they set foot on your property again, call the police." The cease and desist letter went out the next day. Robert's firm was thorough. The letter outlined the legal impossibility of including my property in the HOA without my consent, cited relevant Wisconsin property law, and demanded that all fines be rescinded and all future enforcement actions cease immediately. Patricia's response came 3 days later, not to Robert but directly to me. Another certified letter arrived, this time with a fine increased to $1,000 and a threat of a lien being placed on my property. "They are doubling down," I told Robert over the phone. "Let them. They are digging their own grave. Every action they take just strengthens our case. Do not engage with them at all." But Patricia was not done. The following week, I came home from a job to find a notice posted on my barn door. It was an official-looking document declaring the barn a nuisance structure and demanding its removal within 30 days. Below that, in smaller print, it threatened daily fines of $250 if I failed to comply. I took a picture of it and sent it to Robert. His response was immediate. "This has crossed into harassment. I am filing for a restraining order and accelerating the quiet title action. Also, I am reaching out to the other property owners who were included without consent. This could be a class action situation." Tom was immediately on board. So were the Hendersons, an elderly couple whose farmhouse had stood since the 1940s. The Martinellis, who ran a small orchard on their property, joined as well. The last 2 properties were owned by people who had moved away and were renting their houses out. But we tracked them down, and they agreed to join the suit. The 6 of us together, represented over 250 acres of land that had been unilaterally absorbed into Pine Ridge Estates without permission or legal authority. Robert organized a meeting at his office. All 6 property owners sat around his conference table while he laid out the strategy. "What they have done is not just improper, it may actually be illegal," Robert explained. "Wisconsin law is very clear about HOA formation. You cannot include properties without explicit consent. The fact that they are now threatening fines and property liens could constitute extortion." "So, what is our move?" Tom asked. "We file the quiet title action as a class, which will definitively establish that your properties are not subject to the HOA covenants. Simultaneously, I am recommending we file a harassment lawsuit against the HOA board personally, not just the association. Patricia Meredith and whoever else is on that board need to understand there are consequences for this behavior." Mrs. Henderson, a sweet woman in her 70s, raised her hand tentatively. "Will this be expensive? My husband and I are on a fixed income." "I am taking this on contingency," Robert said. "When we win, and we will win, the court will order them to pay all legal fees. This will not cost you anything." The lawsuit was filed 2 weeks later. I was not expecting the reaction we got. 3 days after the filing became public record, I found my driveway blocked by 2 pickup trucks and a cluster of people holding signs. As I got closer, I could make out the messages: "Support our community," "No to commercial blight," and my personal favorite, "Keep Pine Ridge beautiful." I parked on the road and walked up to the group. There were about 15 people, all residents of the new subdivision. Patricia stood in the center, directing the operation like a general commanding troops. "What is this?" I asked. "A peaceful protest," Patricia announced loudly, clearly performing for the group. "You are destroying property values with your refusal to comply with community standards. These residents have a right to voice their concerns." "On my private driveway, we are on the county road," she said, gesturing to where their vehicles were technically parked on the shoulder. "We have every right to be here." A younger woman stepped forward, her face flushed with anger. "Do you know what you are doing to our home values? We bought here because it was supposed to be a nice community, and you are running a junkyard." "I am running a business from a barn that has been here for a century," I said calmly. "Your developer built around my property. That is not my problem." "You are being selfish," another person shouted. "You should think about the community." "I am not part of your community. I was here first." The protest continued for about an hour. I ignored them and went about my business, but the whole thing left a sour taste in my mouth. These people had been fed a narrative by Patricia, painted as the villain in a story I had not even asked to be part of. That evening, a truck from the local news station showed up. A reporter named Jennifer Chen knocked on my door with a cameraman in tow. "Mr. Ingram, I am with Channel 7 News. We heard about the dispute with the HOA. Would you be willing to tell your side?" I hesitated. Part of me wanted to avoid the attention, but another part realized that public opinion might actually matter here, especially if this ended up in front of a jury. "Sure," I said. We did the interview on my porch, with the barn visible in the background. Jennifer was thorough and fair, asking about the history of my property, the HOA's claims, and the lawsuit. I explained everything clearly, emphasizing that I had never agreed to be part of their association and that my barn had been standing since 1923. "The HOA claims your equipment storage violates aesthetic standards and is hurting property values," Jennifer said. "What is your response?" My response is that they built a subdivision around an existing farm. I was here first. My barn was here first. They do not get to decide what I do with my own property just because they drew some boundaries on a map. The story aired that night on the evening news. The response was immediate and overwhelmingly in my favor. Social media lit up with comments supporting property rights and criticizing HOA overreach. By the next morning, the story had been picked up by regional outlets and was trending on local Twitter. Patricia did her own interview, of course. She went on about community standards and property values, painting herself as a defender of neighborhood integrity. But she made a critical mistake during the interview. These properties were included in our boundaries for a reason, she told the reporter. The entire area needs to maintain consistent standards. If we allow one person to ignore the rules, it sets a precedent. Robert nearly jumped out of his chair when he saw the clip. She just admitted on camera that they deliberately included properties without consent. That is Exhibit A right there. The quiet title hearing was scheduled for 6 weeks out, but things escalated before we ever got to court. Patricia, apparently emboldened by what she perceived as support from the Subdivision residents, decided to take matters into her own hands. I was in town getting supplies when I got a frantic call from Tom. "You need to get home right now," he said, his voice tight with urgency. "There are people at your barn." I broke every speed limit getting back. When I arrived, I found 3 trucks parked near my barn and a group of about 8 men standing around examining the building. Patricia was there too, directing them and taking photos with her tablet. "What the hell is going on here?" I demanded, jumping out of my truck. Patricia turned to me with a smug expression. "We are conducting a structural assessment. The board has concerns about the safety of this building. If it is found to be unsafe, we can mandate its removal under county codes. Get away from my barn. Get off my property right now." "We have a right to ensure community safety," she said. "No, you do not. You have no rights here at all. Leave or I am calling the police." "Go ahead and call them. We are not doing anything illegal." So I did. I pulled out my phone and dialed 911 right in front of them. The Portage County Sheriff's Department had a substation about 15 minutes away. "I need to report trespassing on my property," I told the dispatcher. "There are multiple people who have been asked to leave and are refusing." Patricia's confident expression faltered slightly. "We are not trespassing. This is part of the community." "No, this is private property and you are not welcome here." The group started to look nervous. One of the men, a contractor by the look of his work clothes, stepped forward. "Hey, I was just hired to do an assessment." "I do not want any trouble." "Then leave," I said. "She does not have the authority to hire you to inspect my building." He looked at Patricia, then back at me, then started walking to his truck. 2 others followed him. Patricia's face went red. "You cannot leave. We are not finished." "Lady, if the cops are coming, I am out of here," the contractor said. "This is not worth it." By the time the sheriff's deputy arrived, only Patricia and 2 other HOA board members remained. Deputy Miller stepped out of his patrol car and assessed the situation. "What is going on here?" he asked. I explained the situation, showed him the property boundaries, and made it clear that I had asked them to leave multiple times. Patricia tried to interject with claims about HOA authority and community safety, but Deputy Miller cut her off. "Madam, do you have permission to be on this property? The HOA has jurisdiction over this area." "That is not what I asked. Does the property owner give you permission to be here?" "No, but then you are trespassing. I need you and your colleagues to leave now. If you return without permission, you will be arrested." Patricia looked like she had been slapped. "This is outrageous. We are trying to protect the community." "Madam, leave now. This is your only warning." They left, but not before Patricia turned to me and said, "This is not over. You are going to regret this." Deputy Miller made a note of that. "Did you hear that?" he asked me. I did. That is a threat. Do you want to press charges? I thought about it. Part of me wanted to, but another part knew it would just escalate things further. Not right now. But I want this documented. Understood. I will file a report. If she comes back or contacts you again, call us immediately. Robert was thrilled when I told him what happened. Threatening behavior documented by law enforcement. This keeps getting better for our case. But Patricia was not done. Not by a long shot. 2 days later, I received a notice from Portage County Code Enforcement. Someone had filed a complaint about my barn, claiming it was structurally unsafe and posed a hazard. The county was required to investigate. The inspector showed up on a Thursday morning. His name was Gary, a middle-aged guy with a clipboard and a tired expression that suggested he had seen it all. "Sorry about this," Gary said as he walked around the barn. "I can tell by looking at it that this is a bogus complaint, but I have to do my due diligence." "I understand. Do what you need to do." He spent about 30 minutes examining the structure, checking the foundation, looking at the roof trusses, testing the door frames. Finally, he signed something on his clipboard and handed me a copy. "Structurally sound," he said. "Actually, this barn is in better shape than most modern construction I see. Whoever built this knew what they were doing. My great-grandfather built it in 1923. Well, he did good work. You are all clear. I will file my report and close the complaint." "Let me guess," I said. "The complaint came from Patricia Meredith or the HOA board." Gary's expression told me everything I needed to know. "I cannot comment on who files complaints. But between you and me, I have gotten about 15 calls from that HOA in the past month about various properties. They are grasping at straws." The hearing for the quiet title action finally arrived in late March. Robert had prepared meticulously. We had property deeds, historical records, the original HOA filing, and testimony from all 6 affected property owners. The courtroom was packed. All the residents of Pine Ridge Estates seemed to have shown up, along with local media and curious onlookers. Patricia sat at the defendant's table with the HOA's lawyer, a harried-looking man named Keith, who I almost felt sorry for. Judge Margaret Reynolds presided. She was a no-nonsense woman in her 50s with a reputation for cutting through legal nonsense. Robert presented our case first. He methodically laid out how the HOA had been formed, how the boundaries had been drawn to include our properties, and how none of us had ever consented to be part of the association. He showed the original deeds, the lack of any HOA covenants attached to them, and the timeline of events. "Your Honor," Robert said, "this is a clear case of overreach. An HOA cannot simply declare someone's property to be under their jurisdiction. Wisconsin law requires explicit consent, either through voluntary signing of covenants or as a condition of purchase from a developer. None of these property owners purchased from the developer. None of them signed anything. The HOA's attempt to enforce their rules is legally baseless." Keith stood to present the HOA's case. His argument essentially boiled down to the boundaries were filed with the county, therefore they are valid. He tried to claim that the property owners had received notice and had failed to object within the required time period. "Your Honor, the master declaration was properly filed, and notice was published as required by statute. The plaintiffs had an opportunity to object and failed to do so. Their properties fall within the described boundaries and are therefore subject to the covenants." Judge Reynolds looked skeptical. "Counsel, are you arguing that publication notice is sufficient to bind someone's property to an HOA without their explicit consent?" Keith hesitated. "The law requires that notice be given. It was given through publication." "That is for informational purposes," the judge said. It does not create binding authority over property that was never voluntarily included. Do you have any evidence that these property owners agreed to be part of your association? The boundaries include their properties, Your Honor. That is circular reasoning. Just because you drew a map does not mean you have authority. Judge Reynolds looked at the documents in front of her. I am looking at Mr. Ingram's deed. It dates to 1923. There is no mention of any HOA. How do you claim authority over this property? Keith did not have a good answer. He tried to pivot to arguments about community standards and property values, but Judge Reynolds was not interested. This is a legal question, not a policy debate, she said. Either you have legal authority or you do not. From what I am seeing, you do not. The hearing lasted about 2 hours. At the end, Judge Reynolds announced she would issue a written ruling within 2 weeks, but her tone made it clear which way she was leaning. Robert and I walked out of the courthouse feeling confident. Patricia, on the other hand, looked like she had been punched in the stomach. "This is not over," she hissed as she passed us in the hallway. "We will appeal." "Good luck with that," Robert said cheerfully. Judge Reynolds's ruling came down exactly 2 weeks later. It was comprehensive and unambiguous. The court found that the HOA had no authority over our properties, that all fines and penalties were void, and that any future attempts to enforce HOA rules against us would be considered harassment subject to sanctions. But the ruling went further. Judge Reynolds found that the HOA's actions constituted bad faith enforcement of non-existent authority, and ordered the HOA to pay all legal fees for all 6 property owners. She also issued an injunction preventing the HOA from any contact with us regarding enforcement matters. The bill for legal fees came to just over $70,000. I thought that would be the end of it. I was wrong. Patricia, faced with a catastrophic legal loss and a massive financial judgment, did what desperate people often do. She doubled down. About a week after the ruling, I noticed something strange. Traffic on my road had increased significantly. Cars were slowing down as they passed my property, sometimes stopping to take pictures. At first, I thought it was just curiosity about the lawsuit, which had gotten significant local media coverage. Then Tom called me. "Have you seen the Facebook page?" "What Facebook page?" Patricia created a page called Concerned Citizens of Pine Ridge. She is posting pictures of your property and encouraging people to report it to every county and state agency she can think of. Environmental protection, zoning, business licensing, you name it. I pulled up the page on my computer. It was worse than Tom had described. Patricia had posted dozens of photos of my barn and equipment, each with inflammatory captions about commercial blight and environmental hazards. She was actively soliciting complaints and providing agency phone numbers and email addresses. The harassment campaign was coordinated and relentless. Over the next 3 weeks, I had visits from the DNR investigating a false report of fuel storage violations, the State Department of Transportation about supposed illegal commercial vehicle parking, the County Health Department about imaginary waste disposal issues, and even the IRS after someone reported I was running an unlicensed business. Each investigation found nothing wrong. Each one required hours of my time and created stress and disruption. And each one could be traced back to the Facebook page and its network of HOA supporters. Robert was furious when I showed him the page. "This is beyond harassment. This is a coordinated campaign of malicious prosecution. We are going to bury them." He filed an emergency motion for contempt of court, arguing that the HOA and Patricia personally were violating the injunction by continuing their harassment through proxy complaints. He also filed a separate lawsuit for defamation and intentional infliction of emotional distress. The contempt hearing was scheduled for May. In the meantime, Robert did something clever. He subpoenaed Facebook for all the records associated with the Concerned Citizens page, including IP addresses and private messages. What those records revealed was damning. The Facebook page was not just Patricia venting. She had organized a systematic campaign with other board members, assigning different people to file complaints with different agencies. The private messages showed coordination, strategy discussions, and explicit acknowledgement that the complaints were baseless but would make his life miserable until he leaves. That last phrase was important. It showed intent to drive me off my property through harassment. Judge Reynolds was not happy when she saw the evidence. At the contempt hearing, she did not mince words. "Miss Meredith, you have willfully and deliberately violated my injunction. You have orchestrated a campaign of harassment that has wasted government resources and caused significant harm to the plaintiff. This is one of the more egregious cases of contempt I have seen in my 20 years on the bench." Patricia tried to argue that she was just exercising her First Amendment rights to raise concerns, but Judge Reynolds cut her off. Organizing false reports to government agencies is not protected speech. It is abuse of process and potentially criminal. "I am finding you and the HOA board in contempt. I am imposing sanctions of $5,000 per board member, payable to Mr. Ingram. Additionally, I am referring this matter to the district attorney for potential criminal charges." The courtroom went silent. Patricia's face drained of color. But Judge Reynolds was not finished. "Furthermore, I am extending the injunction to prohibit any contact, direct or indirect, between the HOA, its board members, and any of the plaintiffs. This includes social media posts, third-party communications, and any other form of harassment. Violation of this expanded injunction will result in jail time. Am I making myself clear?" "Yes, Your Honor," Patricia whispered. The criminal referral was the beginning of the end for Patricia's reign of terror. The Portage County District Attorney, a sharp prosecutor named Jennifer Walsh, took the case seriously. She reviewed all the evidence, including the Facebook messages, the false reports to government agencies, and the pattern of harassment. 3 weeks later, criminal charges were filed. Patricia and 2 other board members, Susan Henderson and Michael Torres, were charged with conspiracy to commit harassment and filing false governmental reports. Each charge was a misdemeanor, but together they carried potential jail time and serious fines. The news sent shockwaves through Pine Ridge Estates. Suddenly, the HOA that had been so aggressive about community standards was front-page news for all the wrong reasons. Property values, which Patricia had been so concerned about protecting, took a real hit as potential buyers saw the headlines about the HOA board facing criminal charges. The other residents of the subdivision began to distance themselves from Patricia. Several homeowners reached out to me privately to apologize. A few even said they had never supported the harassment but had been afraid to speak out against the board. The HOA itself went into crisis mode. An emergency meeting was held. Patricia and the other charged board members were forced to resign, and new leadership was elected. The new president, a reasonable guy named David Chen, reached out to Robert to extend an olive branch. "We want to make this right," David told him. "The previous board acted improperly and does not represent the values of our community. We are prepared to settle all outstanding matters and ensure this never happens again." The settlement negotiation was straightforward. The HOA agreed to pay an additional $50,000 to the 6 property owners whose land had been improperly included, to cover damages and ensure we were made whole. They also agreed to file amended boundary documents with the county that explicitly excluded our properties, and to send formal letters to all members clarifying that our land was never part of the association. Most importantly, they agreed to establish clear policies preventing future boards from this kind of overreach. The criminal case against Patricia moved forward. Her lawyer tried to negotiate a plea deal, but DA Walsh was not feeling generous. The case went to trial in September. I testified about the harassment, the false complaints, and the disruption to my life and business. Tom and the other property owners testified as well. The prosecution presented the Facebook messages, the documented false reports, and expert testimony about the coordinated nature of the campaign. Patricia's defense was weak. Her lawyer tried to argue that she had genuinely believed the complaints were valid, but the Facebook messages contradicted that. In one particularly damning exchange, she had written, "I know the complaints will not stick, but each one costs him time and money. Eventually, he will give up." The jury deliberated for less than 3 hours. Guilty on all counts. At sentencing, Judge Ramirez, who presided over the criminal case, was blunt. "Miss Meredith, you abused your position as HOA president to wage a personal vendetta against someone who was simply trying to live on their own property. You wasted government resources, caused significant distress, and showed no remorse until you were caught. This behavior cannot be tolerated." Patricia was sentenced to 90 days in county jail, to be served on weekends over the course of a year, plus 5 years of probation and a $10,000 fine. The other 2 board members received probation and community service. As I walked out of the courthouse that day, I felt a weight lift off my shoulders. The ordeal was finally over. Life returned to normal surprisingly quickly. My snow removal business continued to thrive. The barn stood as it always had, weathered red wood and white trim, a testament to my great-grandfather's craftsmanship and my family's long history on the land. The new HOA leadership turned out to be reasonable. They focused on the actual subdivision and left those of us on pre-existing properties alone. David Chen even hired me to plow the subdivision streets during winter, which was both ironic and satisfying. Tom and I became good friends through the whole ordeal. We would sit on my porch some evenings, drinking beer and watching the sun set over the fields, talking about the absurdity of what we had been through. "You know what the craziest part is?" Tom said one evening. "All they had to do was leave us alone. Just acknowledge that we were here first and respect property boundaries. Instead, they created a nightmare for themselves." "Pride," I said. Patricia could not stand being told no. She had to be right, had to be in control, even when she was clearly wrong. Well, she learned a hard lesson. The following spring, I did something I had been planning for a while. I had a local craftsman make a large wooden sign that I mounted on the barn. It read, "Ingram Farm, established 1923. Below that, in smaller letters, "Here first, here to stay." It was not meant as a provocation, just a statement of fact. But I would be lying if I said it did not give me satisfaction every time I looked at it. The lawsuit settlements and the various judgments meant I had some extra money. I invested it back into the property, repairing some of the old fence lines, upgrading my equipment, and even adding a small addition to the barn for better storage. I also started documenting the property's history more formally. I found old photos of my great-grandfather standing in front of the barn the year he built it, pictures of my grandfather working the fields, and images of my father on the same land. I had them digitized and created a small display in my home office. This land was more than just property to me. It was legacy, history, and family. That was something Patricia and the original HOA board never understood. They saw my barn as an eyesore affecting their property values. I saw it as a connection to generations of my family who had worked this land, built their lives here, and passed it down. The story got picked up by a few national news outlets, mostly in the context of HOA overreach and property rights. I did a few interviews, always emphasizing the same points: respect for property rights, the importance of understanding what you actually have authority over, and the dangers of unchecked HOA power. One interview I did was for a property rights organization that used my case as an example in their advocacy work. The lawyer I spoke with told me that situations like mine were more common than people realized, though few fought back as effectively. "A lot of people just give up," he said. "They pay the fines, or they move, or they comply even when the HOA has no real authority. You stood your ground and exposed the whole corrupt system. That matters." By the time winter rolled around again, everything had settled into a comfortable routine. My barn was full of equipment, ready for the snow season. My business was booming, and my property stood as it had for over a century, unbothered by HOA nonsense. I was out in the barn one December afternoon doing some maintenance when I heard a car pull up. For a moment, old instincts kicked in and I tensed, but then I recognized David Chen's sedan. He got out and walked over, hands in his pockets. "Hey, Lawrence, got a minute?" "Sure. What's up?" "I wanted to thank you, actually." The whole situation with Patricia and the old board was a wake-up call for a lot of us. We have completely restructured how the HOA operates. More transparency, term limits on board positions, and a strict policy against enforcement actions without proper legal review. We are even talking about converting to a voluntary HOA model. That is good to hear. I also wanted to apologize personally. I was not on the board back then, but I lived in the subdivision and I did not speak up when I should have. I knew what they were doing was wrong, but I stayed quiet. I am sorry for that. I appreciated the honesty. Takes guts to admit that. Apology accepted. We talked for a few more minutes and then he left. It was a small moment, but it felt significant. Accountability, genuine remorse, and a willingness to do better. If only Patricia had been capable of that from the start, none of this would have been necessary. The years that followed were peaceful. I continued running my business, maintained the property, and enjoyed the quiet satisfaction of knowing I had stood up for what was right. Tom and the other property owners who had been swept up in the HOA's overreach also moved on, though we stayed in touch and occasionally got together to share a laugh about the whole absurd situation. Patricia completed her jail time and probation. I heard through the grapevine that she moved away from the area, which was probably for the best. The other board members who had been charged faced similar consequences and also moved on with their lives. The Pine Ridge Estates subdivision continued to grow, but in a more measured way. The new HOA leadership kept their focus where it belonged, on the properties that had actually agreed to be part of the association. They left me and the other historic properties alone, which was all we had ever wanted. One of the most satisfying outcomes was watching my nephew, who was studying law at the University of Wisconsin, use my case in one of his property law classes. He told me his professor held it up as a textbook example of HOA overreach and the importance of understanding the limits of your authority. "Your barn is in my textbook," he told me with a grin. "There is a whole section on your case." That barn, the the one my great-grandfather built with his own hands in 1923, had become more than just a family landmark. It was now a symbol of property rights, of standing up to bullies, and of the importance of respecting history and law. I never sought out that kind of attention or significance. I just wanted to be left alone to live on my property and run my business. But sometimes you have to fight for simple things, for basic rights, against people who think they have authority they do not actually possess. Looking back, I do not regret any of it. Yes, it was stressful and time-consuming and expensive before the settlements covered everything. Yes, it would have been easier to just comply or move away. But this was my land, my family's legacy. And I was not about to let some power-hungry HOA president with a sense of entitlement take that away. The barn stands today as it has for over a century, red paint fresh, white trim bright, full of the equipment I need to run my business and serve my community. On cold winter mornings when I am loading up the plow truck before dawn, I sometimes think about my great-grandfather doing similar work 100 years ago. Different equipment, different challenges, but the same dedication to the land and to honest labor. That continuity means something. It is a thread connecting past to present, family history to current life. Patricia Meredith never understood that. To her, my barn was just an obstacle to her vision of suburban perfection, something that did not fit the aesthetic she wanted to impose. But history does not bend to HOA covenants. Property rights do not disappear because someone draws new boundaries on a map. And family legacy is not erased by fine notices and harassment campaigns. In the end, justice prevailed. The law worked as it should. The courts recognized the truth and acted accordingly. The criminal system held people accountable for their harassment and abuse of power. And life went on, better and more peaceful than before. I still live on my 43 acres in rural Wisconsin, just outside Stevens Point. I still run my snow removal business from my barn. I still maintain the property my family has owned since 1923. And I still sleep well at night, knowing I stood my ground when it mattered. The sign on my barn says it all. Ingram Farm, established 1923. Here first, here to stay. And that is exactly what I intend to do.